Thank you so very much. Good afternoon, everyone. Before we begin the public hearing, I will make the following announcement. Due to the continuing threat of public health from COVID-19, City Council committees are currently meeting remotely. We are using Microsoft Teams to make these remote hearings possible. Instructions for how the public may view and offer public testimony and public hearings of council committees are included in the public hearing notices that are published in the Daily News, Inquirer, and Legal Intelligencer prior to the hearings and can also be found on phlcouncil.com. I now note that the hour has come. Rachel, will you please call the roll to take attendance? Members that are in attendance, will you please indicate that you are present when your name is called? Also, please just say a few brief words when responding so that your image will be displayed on screen when you speak.
Vice Chair Derek Green.
Good morning, Madam Chair, members of this committee. I am present.
Morning. Afternoon.
Councilmember Helen Gem.
Good afternoon, Madam Chair. Good afternoon, colleagues. I am present.
Afternoon.
Councilmember Curtis Jones Jr.
Madam Chair, colleagues, Philadelphia, I'm present.
Afternoon.
Councilmember Brian O'Neill.
I am present.
Afternoon.
Councilmember Cindy Bass.
Good afternoon, Madam Chair and colleagues. I am present.
Afternoon.
And we are joined by Council President Darrell Clark.
Good afternoon, Madam Chair, members of the committee. I'm present.
Good afternoon, Mr. President. This is the public hearing of the Committee on Law and Government on bill numbers 220-187, 220-049, 220-360, and 220-361, and resolution number 220-197. All other bills and resolutions are being held. After the clerk reads the title of the bills, I am going to be acknowledging our Council President, Darrell Clark, for some remarks. But for right now, Rachel, will you please read the title of the bills and the resolution being heard today?
220187, an ordinance providing for the submission to the qualified electors of the City of Philadelphia of an amendment to the Philadelphia Home Rule Charter to create the Department of Aviation, to transfer the functions of certain city agencies with respect to the operations at the city's airports to the newly created department, and to provide for additional duties of the department as approved by resolution of the City Council, fixing the date of a special election for such purpose, prescribing the form of ballot question to be voted on, and authorizing the appropriate officers to publish notice and to make arrangements for the special election. 220049, an ordinance amending Chapter 20-1000 of the Philadelphia Code, political contributions and expenditures, to add and make changes to provisions regarding campaign contributions and disclosure of political committee expenditures, all under certain terms and conditions. 220360, an ordinance amending Chapter 20-600 of the Philadelphia Code, standards of conduct and ethics, by revising and extending the prohibition on retaliation and adding protections against interference with Board of Ethics proceedings, all under certain terms and conditions. 220361, an ordinance amending Chapter 20-1000 of the Philadelphia Code, political contributions and expenditures, to revise provisions and to make technical changes, all under certain terms and conditions. And 220197, a resolution proposing an amendment to the Philadelphia Home Rule Charter to create the Department of Aviation, to transfer the functions of certain city agencies with respect to the operations at the city's airports to the newly created department, and to provide for additional duties of the department, and providing for the submission of the amendment to the electors of Philadelphia.
Thank you. Before we begin to hear testimony from the witnesses we have for today, everyone who has been invited to the meeting to testify should be aware that this public hearing is being recorded. Because the hearing is public, participants and viewers have no reasonable expectation of privacy. By continuing to be in the meeting, you are consenting to being recorded. Additionally, prior to recognizing members for the questions or comments they have for witnesses, I will note for the record at this time that we will use the chat chat feature available in Microsoft Teams to allow members to signify that they wish to be recognized. In order to comply with the Sunshine Act, the chat feature must only be used for this purpose. At this time, I want to recognize our president, Darrell Clark, for comments.
Madam Chair, thank you and good afternoon, members of the committee. Madam Chair, per our conversation earlier, would like to officially ask that Bill number 210-630, 220-408, 220-409, 210, Resolution 640, and 220, Resolution number 423. Those bills reference the change in the Home Rule Charter to create a public works residency provision. The bill was written by the Law Department. Late last week, received a memo from the Law Department that indicated, as written by them, this may not necessarily be enforceable. So we will hold that bill so we can determine the enforceability if it is altered. So we're going to hold that for now. The other bill that talks about the division of jobs and training opportunities, and I know there has been significant conversation by yourself and Councilwoman Catherine Gilmore Richardson with respect to that. There was a flurry of phone calls, which is good, leading up to the possible passage or the hearing for this particular bill. And a number of individuals, and I want to reference particularly Pat Clancy, who is currently running Philly Works, indicated that there may be a way of achieving the goals of the legislation without necessarily having a charter change, which I'm always in favor of. So we will shortly have a conversation with the interested parties and the stakeholders to try to craft something to make sure that there's no gaps in opportunities. Philly Works does great work. No one can question that, but based on the funding formula, there are a significant number of people that may not necessarily qualify to participate in that. We have to figure out a way to make sure that everybody gets an opportunity. So with that, Madam Chair, we're going to ask for the holding of all those bills, and I appreciate your indulgence on this matter, and I want to thank Mr. Clancy for the conversation that we had over the weekend. So thank you, Madam Chair.
Thank you, Mr. President, for your summary and providing an overview about those bills and the resolution. The record will reflect that those bills are being held today. Again, thank you, Mr. President, for being here and for providing that summary. With that being said, Rachel, will you please call the first panel that we have to testify this afternoon on bill number 220187 and resolution number 220197.
Yes, we have Rochelle Shelley Cameron, and then there are others available from the airport for questions if need be.
Thank you so very much. Good afternoon, Shelley. I see you in a box here. Gosh, it's so different, but it'll change soon. You are connected, so just state your name for the record and proceed with your testimony.
Good afternoon, Chairperson Parker and members of the Committee on Law and Government. My name is Shelley Cameron, Chief Executive Officer for the Division of Aviation, which manages both Philadelphia International Airport and Philadelphia Northeast Airport. I am here today to testify in support of Bill number 220187 and Resolution number 220197, which would submit to the citizens of Philadelphia an amendment of the Home Rule Charter to create a Department of Aviation. With me today are members of my leadership team, Tracy Borda, Chief Financial Officer, and Alicia Wiles, Chief Administrative Officer. Also with me today to take questions is Commerce Director Ann Nadel. Commerce and the Division of Aviation have a strong partnership that I'm confident will continue into the future. Our city's airports, PHL and PNE, are key regional assets that combine to generate billions in economic impact and help sustain more than 106,000 jobs. To succeed into the future, we need to ensure that PHL and PNE are in the best position to operate efficiently and to adapt to changes in the business environment. The need to make major changes in airport operations quickly during the pandemic has taught us the value of efficient decision-making. With the support of the administration, our leadership team has been thoughtfully working on a charter change proposal which would create a new Department of Aviation to provide the city's airports with stability from administration to administration and to enable our team to meet changes within the industry head-on. A comprehensive overview of the benefits this change could bring to the airport, its stakeholders, and passengers has been provided to this body. I would like to touch on a few of the key benefits during my testimony today. First, a key function of this charter change would be to institutionalize processes and procedures to ensure efficient decision-making. For example, under this change, the airport director would be able to sign grant agreements, contracts, and other binding documents on behalf of the City of Philadelphia. Why is this important? Prior to the current signatory process instituted by the Kenney administration, airport agreements and other important contracts needed to be signed by other members of the administration. This resulted in delays conforming grant agreements, signing leases, and authorizing other important contracts. The benefit of institutionalizing the current process is that it will provide passengers, employees, contractors, and stakeholders a quicker delivery of projects and services. Secondly, having an adaptable workforce able to evolve to meet changes within the industry is vital. A Department of Aviation would be able to recruit for talent for key roles not found in other departments and hire for all airport positions more efficiently. Establishing and growing new teams within PHL, such as guest experience, which was implemented during the pandemic, or passenger services, help serve our passenger base and support our on-site team members. Through this change, the airport team would be afforded the ability to create new positions and make specific personnel units more scalable to better respond to changes within the industry. Finally, this change would make the department head a member of the mayor's cabinet and better position the director of aviation to advocate for important policy changes that would benefit employees and passengers. Even though the reporting structure would be different, aviation would continue to partner with the Commerce Department on important business development initiatives that benefit our city and residents. I'd like to thank you for the opportunity to present testimony today. I kindly ask the committee for a favorable recommendation, and I'm happy to answer any questions you may have.
Thank you so very much, Shelley, for your testimony. Let me state for the record and for the benefit of the viewing public that this bill and resolution was introduced by Councilmember Kenyatta Johnson on behalf of Council President Clark. Councilmember Johnson represents the district in which the airport is geographically located. So I wanted to note that for the record. Shelley, I would have had a ton of questions for you. However, any and every question that I could think of, we asked during budget hearings already, and that information has been put on the record. I want to ask, are there any questions or comments from members of the committee? Chair recognizes Council Member Jones.
Thank you so much, Madam Chair. I want you to think about the top 5 reasons we should do this. I think I know many of them, but I'd like to put it on the record. I know how much, just in my tenure with the city, how much the airport and aviation has grown. We are in a lot of senses, an independent city out there, with commerce, with railways, internal transportation systems, with the whole parking environment, and with no disrespect to the Commerce Department, I come from that DNA, if you would, by way of work experience, but it always was like the tail wagging the dog in the sense of how federally slanted aviation is and how private sector-y it could be based on the 9 or so, back in the day, airlines that used to be out of that airport. So I kind of get why, but do me a favor and take a deeper dive for the record. The 5 reasons we should do this.
Oops, sorry about that. Thank you for the question, Councilmember Jones. I think first I would start by saying that the 3 reasons that I outlined in my testimony stand, right? It's the efficiency of the operations, being able to sign agreements quickly, to be able to keep projects and services moving. It's the workforce issues, having the ability to add additional exempt positions when required. A perfect example of this is we added a director of guest experience, which is a program that many airports had instituted years ago. And it was only through borrowing, if you will, a position from the managing director's office and filling that position were we able to establish that function. So it's workforce issues. And then finally, it's being a member of the mayor's cabinet. I would point out that when the charter was written, aviation didn't have near the impact that it has today, as you noted. Other cities have realized this impact, and we did a lot of research leading up to this recommendation. Other large hub airports and large cities that have city-owned and operated airports like us have aligned their aviation, their airports as direct reports to their mayors. Examples are Denver, Chicago, Atlanta. These are some of the leading airports, not just in the country, but in the world. And, we really see this as a modernization, if you will, of the alignment to make sure that we are kind of keeping up with our peers. I talked about the other things, but, one other thing that I would mention is to make sure that policy priorities can be acted on quickly. During COVID, we were one of the city divisions areas that were on site every day. So vaccine rollout and decisions about how to keep our workforce safe were things that we really would have benefited by having more direct access to the decision makers. So it's for all of those reasons that I think this makes sense, not just for the airport, but really for the city and its residents as well.
Many of your rules and guidelines are federal rules and guidelines anyway, correct?
That is absolutely correct. A lot of the things that we do are governed by grant assurances and other FAA, TSA, and CBP regulations. That is correct.
And give us a sense of scope. And I did not, Madam Chair, forgive me for the redundancy in this. I did not actually hear their testimony. So for you, it's secondhand. For me, it's first time out. How many employees do you have, just to give the public a sense of how large you are? How many employees are at the airport? And also include the airlines employees in that.
Yes, of course. The Division of Aviation, when we staff up to the levels that we need to be, we're a little low right now because of the pandemic, but we have more than 800 Division of Aviation employees and another 200 public safety, so police and fire employees that are at the airport that work for the city. But before the pandemic hit, there were 21,000 people who work at the airport. So the other 20,000 work for predominantly the airlines, rental car companies, concession operators, and I could keep going on and on. TSA has more than 5,000 employees. So it's more than 20,000 employees that work for all those other companies.
So in a lot of cases, you're bigger than some small cities.
Yes, we are.
Thank you, Madam Chair.
Thank you, Councilmember Jones. And no, it was very important to get that information on the record. And because you opened that up regarding the number of employees, tell us, if you will, when you describe that 21,000 who work at the airport but work for the airlines, people know that we have not yet signed an agreement. I know you answered this question already, and this is what I was really referencing, Councilmember Jones, because this question was answered on the record in regards to what is standard operating procedure if an agreement is not signed by a certain amount of time, and what happens with those employees. Put that on the record for us, if you will, Shelley, so members of the public will get a sense of if, in fact, an agreement is not signed. Does that mean that our airport stops working? What does that mean for the people who work for those airlines who are there, but in many cases are residents of Philadelphia?
It's a great question, Chairperson Parker, and I'd be happy to answer it. If we don't have an agreement in place by June 30th, which is the date when our current agreement expires, we will go to rates by regulation. Our current agreement has, we had 2 one-year options, and those have both been exercised, and those options are exhausted. So we would go to rates by regulation. We have already filed rates by regulation and started the official process to establish those, and essentially what that means in practical terms is that we will have a way to charge the airlines for use of our facilities, and we will have general governing rules by which they have to operate. So everything stays essentially the same as it does under an agreement, but especially in the short term, it allows us to keep going in the right direction. We could do this long term, but ideally we would all like to be operating under an agreement.
No, thank you so very much for providing that clarity for the record. Again, you did clearly answer that question regarding the rates by regulation. You got it on the record during the hearing, but when Councilmember Jones was able to sort of get the number of employees who work there, that was important to affirm. So thank you, Councilmember Jones, for just getting that line of question on the record. And now the chair is going to recognize Councilmember Green.
Thank you, Madam Chair. Thank you, Ms. Cameron, for your service at the airport. Good luck in your new role at the Greater Philadelphia Chamber of Commerce. But we'll have just a few quick questions, which this would be for more likely your successor at the airport. And considering the size of the airport, I understand it would be the 10th largest division of aviation in the country. And I know you, as someone who's been in this industry for some time, from your time in DC, and also very cognizant of all the other changes that have happened in the industry. What opportunities do you see, or better opportunities will you see, by having this division in this new role, assuming that it is supported and it comes to pass in reference to opportunities like the bipartisan infrastructure law? No, I'm sure you're very familiar with having LAX, with the major expansion they've done in Los Angeles Airport to make parking much easier in that location. I've been there several times. My sister lives in California. I know the challenges in parking at LAX, but trying to enhance the customer experience. And you talked about having a person in that role. So just like with the bipartisan infrastructure law, other opportunities, what will this change mean going forward in reference to Division of Aviation?
Again, thank you for the question, Councilmember Green. I think that most importantly, it gives us a seat at the table where decisions are being made and discussed and contemplated. When you're not at the table, sometimes you're an afterthought, and we do operate with so many federal guidelines, as Councilmember Jones said, that sometimes people think that everything is just happening at the airport, but we need to be part of a more consolidated strategy moving forward with the city, so that everything that we're doing as a city moves together in tandem, that we're incorporating sustainability goals, that we're accessing money that makes sense to all of us, and that it works together. And I think that this charter change mainly will allow us that access and that seat at the table for those decisions.
In your fact sheet, you talked about the work you're doing with Mike Carroll and the Mayor's Office of Transportation and Utilities. What is happening now in reference to the Infrastructure Investment and Jobs Act, in reference to looking at how we can make critical investments at the airport? Is there coordination with the administration in that regard, or is the airport, and if this does pass the Division of Aviation, moving in a direction where they're focused on their perspective, but it's not being coordinated with other parts of the administration?
So we are coordinating now, but that again, that's not always the case. And as we move forward, so let me give you an example. We have said that we would use our infrastructure dollars to advance our cargo development program. That doesn't just impact building cargo buildings on the airport; it impacts roadways, right? And so some of the coordination that I'm talking about that has happened now with Mike Carroll's office is that we're talking about additional access to I-95 and how we as a city can work together to prioritize that airport project along with other projects that the city has on the books. And again, it all has to work in tandem. If we build those additional cargo buildings and don't have the additional access onto I-95, those trucks could potentially have to go through the airport to get to another slip ramp, which would really gridlock traffic on the airport. So again, we are doing that coordination now, but in the future, it would be very helpful to make sure that we're at the table from the start when those decisions are being contemplated.
Thank you. Thank you, Ms. Cameron. Thank you for your service. Thank you, Madam Chair.
Thank you.
Thank you so much, Councilmember Green, for getting those questions on the record. Are there any questions or comments from other members of the committee? Hearing none, thank you so very much, Shelley, for being here with us today. And if anything comes up after the fact, we'll make sure we forward it to you for a response. But thank you for being here to testify today on Bill number 220187 and Resolution number 220197. There being no more questions, Rachel, I'm going to ask you to call the first panel that we have here to testify this afternoon on Bill numbers 220049, 220360, and 220361. But before they begin, we're going to hear from sponsor Councilmember Derek Green.
Thank you, Madam Chair. These three bills, 049, 360, and 361, hope to provide some additional change to the ethics laws in the city of Philadelphia. The first piece of legislation, 049, helps to address a loophole where someone can basically bring in a vendor to run their campaign and will not have and through our current structure, we'd not have the real ability to have oversight in reference to how that would occur. So this first bill will address that issue, making sure that those who are desiring to run in the city of Philadelphia do not have the ability to outsource their campaign to a third party. And then we don't have the ability, especially constituents and citizens in the city of Philadelphia, to get a perspective on the operations of that vendor as they provide the campaign apparatus for a candidate running for office, which is really not fair to others who are running their campaigns but are not using outside vendor to run their campaign. The second bill, 360, deals with whistleblowers and really just strengthens the protections to make sure that anyone that is providing information regarding ethics violations, that there cannot be retaliation against them for providing that information. I think it provides additional guidance and support to make sure that we are consistent with the goals of all of us as elected officials who took a duty and oath to provide and support the Home Rule Charter. Will continue to do so, and also give citizens within the city of Philadelphia that see ethics violations occurring, the freedom to be able to come forth with those observations and information and not fear retaliation for doing so. And then the final bill is Bill 220361, which really deals with technical issues in our ethics codes, ethics laws that need to be cleaned up. For example, throughout our ethics laws, we make reference to candidate. but then we also make reference to the entire process, which is a campaign, which a candidate is part of. So this is a bill to clean up that language within our ethics laws. There's some other technical changes as well. I'll have Mr. Cook talk about those things. But 220361 is really to clean up the ethics laws and make it more readable, more plain English, and more understandable for anyone that is looking and wants to get an understanding of the laws that operate in the city of Philadelphia as it pertains to ethics. Thank you, Madam Chair.
Thank you so much, Councilmember Green. Rachel, will you now call the first panel we have to testify this afternoon on bill numbers 220049, 220360, and 220361?
Yes, it is just Michael Cook, although there's written testimony from Pat Christmas.
Thank you so very much. The written testimony from Pat Christmas will be officially added to this committee's record. Right now, I see Mr. Michael Cook. Good afternoon. I see that you are connected and ready to proceed. Just feel free to state your name for the record and proceed with your testimony.
Thank you, Madam Chair. Good morning, Chair Parker, Vice Chair Green, Council President Clark, members of the committee. My name is Michael Cook. I'm the General Counsel for the City's Board of Ethics, and I am pleased to be here today to speak on bills 220049, 220360, 220361, and I appear on behalf of the board to testify in support of all three bills. I will just at the outset apologize if you're picking up some glare behind me. It seems like the shades in my office are not blocking it as much as might be ideal. So apologies if that is distracting to anybody. So I'll start with Bill 22049, which would amend the city's campaign finance law to tighten rules related to campaigns making expenditures through vendors. And I understand that Councilmember Green plans to propose an amendment to this bill that would generally update the rules about how candidates use political committees, and would update also an existing provision related to payments by candidates to political committees to be on sample ballots, and would create a new provision allowing candidates to run as slates and share costs. Bill 220360 would amend the city's ethics code to revise and extend the existing prohibition on retaliation and add protections against interference with Board of Ethics proceedings. Bill 220361 would make technical changes to the city's campaign finance law to make wording more consistent and clear. Would also revise the provision related to doubling of the contribution limits to set a specific time period in which contributions from a candidate to their campaign will count towards the doubling threshold of $250,000. Just in closing, note that the board believes all three of these bills would be an improvement to the existing laws and commend City Council for taking up these matters. And I am, of course, happy to answer any question committee members may have.
Thank you so very much, Mr. Cook, for your testimony. Councilmember Green, as the sponsor, are there any comments aside from what you said or questions that you wanted to ask before we go to other members of the committee?
I'll let other members of the committee ask questions, and I may have some follow-up after they have questions.
Okay, thank you. Chair recognizes Councilmember Gill.
Yes, thank you so much, Madam Chair. Good afternoon, Mr. Cook. Thank you so much for your testimony, and thank you very much to the sponsor of the bill as well. I had a few questions. So I think my first question is around, I think it is 220, I hope I'm getting it right, 049. This is regarding the section that talks about vendors and sub-vendors. Section 13, a campaign may pay a political committee or other person to have the candidate's name placed on sample ballots, et cetera. In the case of such payment being made to a person other than a political committee, the campaign shall disclose not just that person to whom it made payment, but also any persons whom that person pays or employs in order to provide the services. So I think one of the questions that I had regarding that is if you could tell a little bit about the thinking, because I think I'm a little confused about how you would see it being reported. I agree that you would want to report the payment to the particular vendor, but I would hope that the campaign isn't responsible for every single line item of any amount that then gets paid for by that vendor. So could you explain to me whether, how a campaign is supposed to maintain the records, or whether that vendor is supposed to maintain the records? I just want to understand the clarity around that.
Certainly. Thank you, Council Member, for the question. And I would say first that the purpose of that particular provision is to avoid situations where campaigns can use, I guess, what you could call the equivalent of shell companies. And so perhaps some LLC or other organization takes money from the campaign and then goes and pays people to do, could be canvassing, get out the vote. It could be a payment to a company for advertising. And by acting as that intermediary, prevents real disclosure from happening. Because if the candidates committee just discloses, say, $20,000 to XYZ LLC, then the public doesn't get the disclosure that they would get from another campaign, say that it's not using that intermediary, so it's disclosing, payments to 10 people for a couple $100 each to do canvassing or whatever the case may be. So that is the concern there and the goal, to ensure a genuine reporting as is contemplated by the law.
And I agree with the general, the overall goal here. My question is, do you feel like shouldn't there be a threshold then for the sub-vendor? Because the intent of this is not for the campaign to be responsible for every single canvasser that may be paid X amount hourly, no matter how small that amount may be. I think the goal is to do what you set out. So do you think that there might or ought to be a threshold minimum before a campaign would have to delineate it?
I think that's a good idea. I had not thought of that before, but I think that makes sense. That there's other places in the law that use similar approach in the campaign finance law to, say below a certain amount of money, we're not going to worry about itemizing, but above a certain amount of money, then yes, the concerns are there.
Yeah.
Madam Chair, I have a point of information.
Please, Chair recognizes Councilmember Green.
Right. A follow those lines, Mr. Cook. I know that there are certain de minimis amounts that you don't have to report from a campaign finance perspective, and I understand that within our campaign finance and ethics laws. But my understanding, and correct me if I'm wrong, it's been some time since I've been what some would say a campaign operative, but campaigns historically had to list every person that received money doing work on behalf of the campaign. I know, for example, wards have to do the same thing, from my understanding. So any party that's doing work or is being paid out of that campaign, that information needs to be disclosed. And my understanding is this would do the same thing to make sure that if you have a vendor, that vendor also has to disclose, just like any candidate that did not outsource their campaign would have to provide that information of who they paid in reference to working on their campaign.
Yes.
Point of information, Madam Chair.
Sure, thank you. Chair recognizes Councilmember Gill.
Just for point of information for Councilmember Green, are you saying, I think we fully agree that the question is the vendor should absolutely be responsible for maintenance of records. The question is whether the candidate and the candidates committee is responsible for the vendor's maintenance of records. Obviously, anything that is directly dispensed to an individual, paid for by the campaign itself, I think there's clear case law that says that obviously you want to delineate all of it, no matter how small that may be. The question here, I think, is whether the vendor's responsible for the information and the reporting, or whether the candidate is responsible for every dollar, no matter how small. So I'm sorry, I just wanted to see, Councilman, if that was your question or if we could clarify that.
Okay, I think I'm not sure if we do questions or point of information, but in that regard, I will respond as one of, the sponsor of the bill. For candidates and also political action committees, they have that responsibility for providing information to the public regarding who's receiving dollars out of their campaign or out of the political action committee. And to me, that is the intent of this legislation, to make sure that if someone is running a campaign and they're hiring people versus someone that is hiring a vendor and that vendor's hiring people, we're not putting a lesser burden on someone doing a vendor situation as opposed to a campaign that did not hire a vendor, who was responsible for demonstrating what dollars came out of their committee to someone or people working on their behalf to position themselves for elective office. I think it puts an unfair burden on those who do not outsource their campaign, or a political action committee that does not have another vendor doing operations on their behalf, to hold them to one standard, but then a different standard if you hire a vendor and then that vendor does not have to provide that type of information.
Chair, Councilmember Gim, did Councilmember Green, in his response to your point of information, did he answer your question, Councilmember Gim? And did you have anything that you wanted to follow up on from Councilmember Green or Mr. Michael Cook?
Sorry, Madam Chair.
Okay, I can hear you now. You were frozen for a bit. You're back now.
Yes, my apologies. Yes, I did want to ask Mr. Cook whether, I think you heard both of our perspectives. I've been very clear that I believe that any amount of money, no matter how small, paid for by a campaign directly to an individual should absolutely be accounted for. I think in a vendor category with a sub-vendor involved, the question is whether the campaign is responsible for every single dollar, no matter how small, of that expense, or whether that was the intent of the bill or of the amendment, or whether the intent is to do what I thought I heard, which is to certainly capture any kind of significant outlay, but recognize that the vendor themselves are responsible for maintenance of records on, small amounts of money that are spent. I think, again, we do a lot with making sure that I think the sponsor of the bill is very aptly, pointing out that we want to capture certain things, but I'm trying to figure out how we do it in a way that it's not excessively burdensome on a campaign, and maybe unnecessarily so, because it's not necessarily trying to get at, do we really want to know the name and amount of money, for example, of every canvasser, no matter how little that it was spent on them, every lunch item, et cetera, or are we trying to capture large scale outsourcing of campaigns in which large sums of money are starting to go out? So I guess I would ask that of Mr. Cook.
Thank you, Council Member. So I would say that the disclosure of even amounts of $100, $150 per person to canvassers is what is contemplated by the amendment as written, as being comparable to what would be required if the campaign itself was making those expenditures, or if they paid the money to a political committee and then the political committee made those expenditures. The political committee would have to disclose those expenditures on its campaign finance report. I think a couple thoughts in regard to your question. One is the burden as written is on the campaign to make those disclosures, and that the law doesn't impose a specific, as the proposed law doesn't propose a specific burden with regard to that on the vendor, which would be different from a political committee, because a political committee, if they're filing campaign finance reports, then they have obligations. So there is a distinction, I think, between the ordinary situations that you might see. I will say, though, that unlike with a political committee, the information here is limited to payments to other persons. So, for instance, if the vendor, is paying for, hoagies or pencils or something, that's not something the campaign has to worry about getting from them. It's the whether it's individuals that they are paying to do the work, or some other LLC that they then pass the work on to down the line, is what's contemplated by the language proposed.
Okay. So there are two things that I had raised as a possibility. One, establishing a minimum threshold so that, there might be, you don't have to do it for a $20 whatever thing. And then the other would be the law could require the vendor to keep records. Is that correct?
So with regard to requiring the vendor to keep records, I think that's right. I think that it would be within the city's power to say that if a vendor wants to provide this kind of service to a campaign, that they would need to maintain documentation showing how everything is spent. And then the law could either say they have to provide that to the campaign, or they have to provide it to the board upon request. I think it would actually make sense to say that they have to provide it to the campaign, because that gives the campaign protection, that they have those records on hand. And then for the first,
could be immediately disclosable at
yes.
anybody's request. Okay.
Yes. Yep. You could do that. And then with the sort of threshold question, I think that could be an approach to strike a balance between getting the disclosures that are desired and also minimizing the burden on campaigns, so that there's not undue burden on campaigns. I would say, though, that I think that the amount, I think, would need to be probably below $100. If a $100 payment is a very typical payment to someone who's doing canvassing or get out the vote activities, and then because otherwise you can have a situation like Councilmember Green was talking about, where you get the kind of unlevel playing field where somebody uses, they do a sample ballot through a political committee, and it's disclosing the 50 people they pay $100 to, and so the public sees all of that. But somebody does it through some LLC, and then they're not disclosing those, even though $100 isn't in its own a significant amount of money. In the aggregate, showing the full scope of what the campaign is actually spending its money on, I think it is significant.
Right. I appreciate that. And I think, the question is like, I believe in disclosure 100%, and I appreciate the attention to it and also capturing sort of the differences. I just want to make sure that candidates and campaign committees themselves aren't put in, an undue kind of position. I think the second question I had a little bit was around, say if the work were to go through as it is, the question is really about reporting. Because I'm not understanding quite how it wouldn't be like some kind of, whether the reporting would make it clear or whether it actually obscure it. So for example, on a committee, say if you paid an entity, I'll give a random amount of $5,000. You do want the public to know that this entity received $5,000, and you generally want that $5,000 to generally be disclosable, right? So, but if the candidate is responsible, is the candidate reporting $5,000 to that entity and then delineating out how the $5,000 is spent? Because I wonder whether it makes it a challenge to not like kind of double report, or say if you don't disclose that it's going to a committee, you might actually, obscure. So how are you handling the way in which it's crystal clear that this entity received a lump sum of this amount, and then underneath it disclose how that money was spent.
So what I would say, this is a great example of something that would be very important for the board in the regulation, to provide that step-by-step instruction to, as you said, to make it crystal clear. As a possibility of what that could look like. And again, there would be a whole regulatory process. So that would play out. But I think we see it'd be so comparable to some of the disclosures that happen with regard to in-kind contributions or campaigns sharing costs and the like. So that, say, for example, somebody pays an LLC $5,000, and $1,000 of it is just the LLC keeps it as their fee, and then $4,000 is they're paying 40 people $100 each. I think I've got my math right there. 40 people $100 each to do the canvassing or whatnot. So what I would say as a way to have the reporting that is accurate, but also doesn't result in double counting, that the campaign on its campaign finance report would disclose $1,000 to the XYZ LLC, administrative cost, and in the description field, administrative cost for canvassing work. And then for each of those 40 people that the LLC paid $100, the campaign would list each of them. And then in the description, say, canvassing work paid for through XYZ LLC. So you would have the full description of what the expenditure was. That's just off the top of my head, though.
Yeah. I mean, again, one of the things that I think that it's important for the public to note that, that these individuals come through this third party entity.
Absolutely.
And I think it makes it a challenge, in my opinion. And in fact, could potentially obscure the amount that goes to the LLC or, to that third party entity. And again, it's part of the reason why I do feel like, consideration of requiring these third-party vendors to have a full maintenance of record down to the penny. I don't really care if the vendor is doing it. And, making that available to the ethics board, to the campaign, and to everybody feels really important. But placing the burden onto the committee and the campaign itself raises to me some questions about whether actually money does get kind of obscured, because you're no longer seeing a lump sum of $5,000 to one entity. You're seeing $1,000 to that one entity and then dispersed over many different people. Now, if that's what you want, maybe, but I think that actually is obscuring, and it makes it also burdensome, but it's mostly that it seems like it's almost, it's not necessarily providing clarity. It's providing a lot of work, but not necessarily providing clarity. And I think that there might be ways for us to continue to talk about how to provide the level of clarity that the ethics board and the public absolutely wants and deserves without, potentially obscuring. So I'll just stop here. My second question is really for the other bill. And is that 0049, or am I on the wrong one? 361. Could you explain, just in your own words, what is the thinking around changing the language again from candidate to campaign?
Certainly. So the campaign finance law was, I guess, it's generally its current version. The original version is 2006, more or less. The 2007 election was the first time it was fully in effect. And then since then, there's been a number of amendments. And the additions, and I think actually for that matter, even in the original version, they didn't always sort of follow the same conventions. So sometimes the ordinance would use the word candidate as a stand-in for the larger campaign, because if you give a contribution to the treasurer or an electronic transfer straight to the committee's account or to the candidate, it's all going to the same place for the purposes of the campaign finance limits. But the law would use the sort of, I don't know, David, it was considered so much, but just the term candidate as in the individual. But there was other places in the law where it would use the term candidate, where it seemed pretty clear that it was meant to actually mean just the individual and not the full operation. So the attempt of this amendment would be to, in the places where the coverage of the law really should be for the whole operation, to use the term campaign, and then in instances where actually it's something specific to the individual who's the candidate, then to use the term there.
So could you clarify about whether, I mean, there's like threshold limits. So this applies threshold limits, obviously, to the campaign and not to the candidate. Does that mean any campaign expenditure to a particular campaign applies towards the individual or PAC limits, even if it's not directly toward that candidate?
So this amendment wouldn't change the application of the contribution limits. It would just be technical wording. Okay. So that, it would be, as is the case now, if somebody gives a check to the candidate themselves, they give the check to the treasurer, it goes through PayPal, it doesn't matter. That's subject to the, $12,000 limit for a $12,100 limit for a PAC. It doesn't expand the coverage of the contribution limits in any way.
Or limit it necessarily.
No.
Okay. All right. Thank you. I just wanted to get that clarified, and I appreciate that. Thank you very much, Madam Chair.
Thank you so very much, Councilmember Gill. Councilmember Green, just a point of information before I get to Councilmember Jones, if you will. The legislation, particularly the exchange between relative to understanding between you and Councilmember Gim, was this legislation that was recommended and recommended as essential and or necessary from the Ethics Committee or board, and saying to council, look, based on our history, based on our experience here, we know we need some clarity here? Or is this your intent, council members, sort of combing through it? I mean, I guess I'm thinking, for example, it would be like if we get a bill from the administration, and they give us a bill and say, we would say, here, Sherelle Parker's introducing this bill on behalf of the administration. Help us, if you will, Councilmember Green, and just explaining how this came about. Thank you.
Thank you, Madam Chair. I've introduced a number of bills, 2 different packages called a civic agenda. This and through working with Mr. Cook and Ethics Board staff, a number of different ideas have come out. This is one idea that did come from the staff of the Ethics Board because of their observation in recent elections, and making it important that we don't want to obscure the ability for voters to get information about who is paying who, and ultimately a campaign and a candidate is responsible for the vendors they pay and the vendors they hire. So making sure that if I am someone that wants to see who paid what, it makes it easier to go directly through the campaign to find that information, as opposed to go through information that a vendor may supply on who they may have paid, but then you got to connect, well, did this vendor work with this campaign? So I've got to find that, kind of be a bloodhound and follow the information. By having it come through and make it ultimately the person who's responsible, the organization that's responsible, which is the candidate, and as the other bill says campaign, they're ultimately responsible for who they hire and who they pay. So it makes sense for that organization to have that information disclosed if a vendor is hired and a vendor is paying people to do work ultimately on behalf of the campaign.
Thank you so very much, Councilmember Green, for that response and letting us know sort of where the intent and or the sort of nucleus of this legislation and where it is proffered from. Chair recognizes Councilmember Jones.
Thank you, Madam Chair, and thank you, Mr. Cook, and thank you, author of this legislation. This is the first time when we're dealing with ethics as it relates to campaigns that it actually seems like the author was somebody who actually ran a campaign. And so I'm thankful for that kind of directness as to the realities of running, as you said, Member Green, of being an operative. So, which I found interesting. A couple of things. One, where are we? Can you take a deeper dive as to when candidates might want to share expenses, might want to be on a ballot collectively, and it is awkward at times trying to account for who's paying for what, how much a pro rata share. That it almost discouraged slates, if you would. So tell me the motivation behind this bill and what this bill will actually do to clarify that.
Thank you, Councilmember Jones. And thank you for that question, because I think it highlights both a particular aspect of the bill that relates to slates that I think is very notable, but then also I really appreciate your comment about the sort of practicality of some of the approach here, because I agree wholeheartedly that that's very important, and that we've had 15 years of experience now in Philadelphia with this campaign finance law, and I think it's one of the strengths of the approach that the city and city council is taking to the law, the flexibility and the willingness to update the law as we go along so that it continues to fit the reality. So it's both accomplishing the goals of the campaign finance law, but not in a way that it becomes unworkable. Because then if it becomes unworkable, then campaigns are going to find themselves in situations where they have really difficult choices to make in terms of how they comply with the law and the realities of campaign stuff. And so I think your point about slates really goes to that, because under the law as it exists now, if 2 candidates or 3 candidates wanted to run as a slate together, they would be significantly limited in how they do so, because once they're doing it together, then they're coordinating their expenditures, and they're each only going to be able to spend up to the contribution limit before they make excess contributions to each other. And that, my observation, becomes a limitation on campaigns that doesn't necessarily further the purposes of the campaign finance law, because there's nothing inherently troublesome, I don't think, about campaigns running as slates. But because of the way the law is currently written, it becomes practically not possible for them to do so. So what this amendment would do would say it's okay to run as slates. Now, you need to make sure that everybody's paying their fair share, that it doesn't become an excuse for a couple of other candidates to fund some favored candidate, that doesn't become a way to get around the contribution limits or anything like that. And so it has those safeguards built into it, with people paying their fair share and maintaining records and so on. But it would allow now candidates to run as slates in a way that they were not allowed to before.
The second question I have is the elephant in the room, both at the federal, statewide, and now local levels. All this transparency is good, but how do you pierce the veil of IEs, independent expenditures, that you don't even know where that money is coming from, what motivations they may have, and then accountability for those dollars coming in? And so there are national entities that are going to come in and because they care about a congressional race or usually something like that, set up shop and kind of manipulate our local elections. So is there any thought? I know these laws do not address that. I get it. But if you're trying to get transparency, the elephant in the room is the independent expenditure.
So I would say, council member, that this, I think, is an area where Philadelphia has really shown leadership in the country in terms of the approach that we have taken through prior amendments to the campaign finance law to ensure genuine disclosure related to independent expenditures, and certainly more than would be required on the federal level, so that the law as written through an amendment in 2015 and then an amendment 4 years ago to really try to create a system of reporting when it comes to independent expenditures, such that the goal of the law as is written to ensure that the actual ultimate funder of a independent expenditure will be disclosed. And that really does relate to the sort of shell company approach that you see in other places. You know, again, it'll be some nonprofit organization that was set up 2 weeks ago is the one writing the check. But the way our law works is it's not enough to just have that XYZ LLC file a report that says, oh, we got our money from ABC LLC, and that's the end of the day. The way our law works is, no, ABC needs to file a report now until you get back to the ultimate funders. Now, I think the law is really good. That I don't want to pretend that there's not challenges with enforcing that, because these folks are well funded, they're very clever. They're always looking for weaknesses in the law. But I think that we do have a very good law on the books for when it comes to independent expenditure reporting, to get genuine reporting in a way that you don't see at the federal level.
Thank you, Madam Chair.
Thank you so very much, Councilmember Jones. I don't see any other questions in the chat for bill number 220-049 or 220-360. And Chair recognizes, is that Councilmember Bass?
Yes, it is.
Chair recognizes Councilmember Bass.
Thank you, Madam Chair. I just really wanted to thank Councilman Green for his thoughtfulness in the legislation that's being proposed today. I think that while I do have some questions and I need to meet with the councilman and the staff to be fully briefed on the matter, but I think at first glance that there are a lot of really positives that I think can come further out of the legislation that's being proposed. So my specific questions were more around the slate concept and how that would work. And I do have some concerns and thoughts around that. But again, I think that that's a matter of clarification that we can have conversation off the record just to have those clarified and not take up any of the committee's time on those matters. But we will be in touch with the sponsor and follow up from there. But overall, I think that, this is definitely the progress that we need to avoid, sort of hiding who's behind the veil and making sure that we get the information out and to know, what entities are actually doing what work when we talk about, not having to list, well, I guess the third party vendors not having to list exactly who they're working with and what kind of activities they're up to. So again, just kudos to Councilman Green, and we will follow up with him directly. Thank you, Madam Chair.
Thank you, Councilmember Bass. Are there, and because I don't have the ability to see any hands raised, I can only see what is actually written in the chat. Vice Chair Green, I'm going to ask you, if you will, do you see any hands up that I've missed, or is there anyone else here?
Madam Chair, I do not see any additional questions being raised by members as indicated in the chat feature of Microsoft Teams.
Thank you so very much, Vice Chairman Green. If there are no more questions. Rachel, do we have anyone else here who is scheduled to testify?
No, we do not.
Okay, and no further questions or comments from members of the committee. There being no further questions from members of the committee and no other witnesses to testify on bill numbers 220187, 220049, 220360, and 220361, and resolution number 220197. I will ask if there is anyone else, excuse me, I will ask if there is anyone else present in this hearing whose name we have failed to call and that wishes to offer testimony on any of these bills or the resolution being considered. Hearing none, I want to thank our witnesses for their participation today. We value your opinions. We will now recess the public hearing and go into a public meeting to consider the action to be taken on these bills and the resolution. We will now convene the public meeting. Rachel, will you please call the roll to take attendance? Members that are in attendance, will you please indicate that you are present when your name is called? Also, please say a few brief words when responding so that your image will be displayed on screen when you speak.
Vice Chair Derek Green.
I am present.
Councilmember Brian O'Neill.
Present.
Councilmember Cindy Bass.
Good afternoon. I am still present.
Councilmember Curtis Jones Jr.
I'm present.
Councilmember Helen Gim. Okay, that's fine. We still have a quorum to vote, so that's fine.
Rachel, was that our final member?
Yes, I do not see Council President Darrell Clark anymore and no other members of the committee.
Okay, thank you. We will now go into our public meeting. The chair recognizes Councilmember Green for a motion on bill number 220187.
Thank you, Madam Chair. I move that bill number 220187 be reported from this committee with a favorable recommendation, and further move that the rules of council be suspended to permit first reading of this bill at the next session of council.
Second.
The chair notes for the record that Councilmember Jones seconds the motion. It has been moved and properly seconded that bill number 220187 be reported from this committee with a favorable recommendation, and further move that the rules of council be suspended to permit first reading of this bill at the next session of council. All those in favor of the motion will signify by saying aye.
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 Those opposed, the ayes have it, and the motion carries. The chair wants to note for the record that council member, one second, please. The chair notes for the record that council member Gim is having technical difficulties. She was sort of knocked off of our platform and is doing her best to get back on right now. So just if her staff is anywhere, please note for the record that Councilmember Gim is having technical difficulties. The chair recognizes Councilmember Green for a motion on resolution number 220197.
Thank you, Madam Chair. I move that resolution number 220197 be reported from this committee with a favorable recommendation.
Second.
The chair notes for the record that Councilmember Jones seconds that motion. It has been moved and properly seconded that resolution number 220197 be reported from this committee with a favorable recommendation. All those in favor of the motion will signify by saying aye.
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 Those opposed? The ayes have it, and that motion carries. The chair recognizes Councilmember Green for a motion on the amendment to bill number 220049.
Thank you, Madam Chair. I offer an amendment to bill number 220049. A copy of the amendment has been circulated to all members of the committee. I move that the amendment to bill number 220049, bill number 220049 be approved.
Second.
The chair notes for the record that Councilmember Jones seconds that motion. It has been moved and properly seconded that the amendment to bill number 220049 be approved. All those in favor of the motion will signify by saying aye.
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 Those opposed? The ayes have it. The motion carries, and the amendment to Bill number 220049 has been approved. The chair now recognizes Councilmember Green for a motion on Bill number 220049 as amended.
Thank you, Madam Chair. I move that Bill number 220049 as amended be approved from this committee with a favorable recommendation, and further move that the rules of council be suspended to permit first reading of this bill at the next session of council.
Second.
The chair notes for the record that Councilmember Jones seconds that motion. It has been moved and properly seconded that Bill number 220049 as amended be reported from this committee with a favorable recommendation, and further move that the rules of council be suspended to permit first reading of this bill at the next session of council. All those in favor of the motion will signify by saying aye.
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 Those opposed? The ayes have it, and the motion carries. The chair recognizes Councilmember Green for a motion on the amendment to Bill number 220360.
Thank you, Madam Chair. I offer an amendment to Bill number 220360. A copy of the amendment has been circulated to all members of the committee. I move that the amendment to Bill number 220360 be approved.
Second.
The chair notes for the record that Councilmember Jones seconds the motion. It has been moved and properly seconded that the amendment to Bill number 220360 be approved. All those in favor of the motion will signify by saying aye.
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 Those opposed? The ayes have it, and the motion carries, and the amendment to Bill number 220360 has been approved. The chair recognizes Councilmember Green for a motion on Bill number 220360 as amended.
Thank you, Madam Chair. I move that Bill number 220360 as amended be reported from this committee with a favorable recommendation. Further move that the rules of council be suspended to permit first reading of this bill at the next session of council.
Second.
The chair notes for the record that Councilmember Jones seconds the motion. It has been moved and properly seconded that Bill number 220360 as amended be reported from this committee with a favorable recommendation, and further move that the rules of council be suspended to permit first reading of this bill at the next session of council. All those in favor of the motion will signify by saying aye.
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 Those opposed? The ayes have it, and that motion carries. The chair recognizes Councilmember Green for a motion on the amendment to Bill number 220361.
Thank you, Madam Chair. I offer an amendment to Bill number 220361. A copy of the amendment has been circulated to all members of the committee. I move that the amendment to Bill number 220361 be approved.
Second.
The chair notes for the record that Councilmember Jones seconds the motion. It has been moved and properly seconded that the amendment to Bill number 220361 be approved. All those in favor of the motion will signify by saying aye.
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 Those opposed? The ayes have it. The motion carries, and the amendment to Bill number 220361 has been approved. The chair now recognizes Councilmember Green for a motion on Bill number 220361 as amended.
Thank you, Madam Chair. I move that Bill number 220361 as amended be reported from this committee with a favorable recommendation, and further move that the rules of council be suspended to permit first reading of this bill at the next session of council.
Second.
The chair notes for the record that Councilmember Jones seconds the motion. It has been moved and properly seconded that Bill number 220361 as amended be reported from this committee with a favorable recommendation, and further move that the rules of council be suspended to permit first reading of this bill at the next session of council. All those in favor of the motion will signify by saying aye.
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 Those opposed? The ayes have it, and the motion carries. I see no questions or comments in the chat. With that being said, this will conclude the business of the Committee on Law and Government for today. This public hearing is recessed to the call of the chair, to members of the committee and viewing public and all of our witnesses. Thank you so much for your participation today. Have a good one.
Thank you, Madam Chair.
Thank you, Madam Chair.
Your allergy medicine, please.